Well, good afternoon and welcome to the presentation. My name is Matthew Parker. I'm an attorney with the firm of Marshall, Parker & Weber, and today we're going to be discussing a variety of incapacity planning tools that are used at a time when we can't handle our financial or healthcare affairs. The presentation is going to take about 30 minutes. If you look at your computer, I think on the right-hand side, there'll be a place where you can ask a question. So if we're going along and you want to ask a question of me about a topic that we're covering, feel free to post it and we'll get to it during the session. Right. For those of you who don't know about my firm, Marshall, Parker & Weber is an elder law and estate planning firm located in Williamsport, Pennsylvania. We've been in business for about 35 years. We prepare estate planning documents for our clients, such as wills, trusts, powers of attorney, and advanced directives. I'm one of the principals of the firm, and I recently celebrated 20 years of practicing law. November of '95 was when I passed the bar exam and started my career. I'm joined today by my assistant, Stacy Zales, who's worked with our firm for some time in the coordination of the marketing efforts, so she's helping out with the technology. Hopefully all is going well from your end. Hopefully you can hear and follow along. If not, certainly contact us. We'll make the corrections if necessary. So with that, I'm going to turn the slide and start the presentation. This area of the law is generally called incapacity planning. The documents and other tools we're going to review today are part of an area of the law that deals with helping people when they can't help themselves. For some reason, their mind has rendered them incapable of making financial or healthcare decisions for yourself. Perhaps you're in a car accident, you've had a stroke, perhaps you've fallen into a coma. There's a disability at issue, such as a mental health issue, or perhaps in many cases there's a dementia or an Alzheimer's disease. And as an elder law firm, we deal with a lot of folks who do have those sorts of issues. So there could be any number of reasons that could arise that require the use of these documents. And a lot of the documents I'm going to discuss today are valuable for any adult of any age. You'd be surprised how many parents I have met whose child, and we're usually talking about a young adult, who was in a car accident. And as a result of that accident, they are incapable of making a decision for themselves about their health care. And these challenges the parents are facing with the healthcare system and trying to make decisions for this adult child can be significant. So having a power of attorney for a child would help them avoid those issues if an accident occurs. So if your kids head off into the brave new world, think of powers of attorney as perhaps a valuable document that they could use for themselves. Now, for most of us, we are contemplating a time when we are older and no longer capable of managing our affairs. Our goals are to remain in control and as long as possible as we age. If not, we generally want an ordered transition to somebody who's going to manage our affairs. So putting a plan in place reduces the burden on loved ones who don't have to scramble at the last minute to determine who's going to manage your affairs. And of course, by putting somebody you trust in place, you have some assurance that your wishes will be carried out. This is particularly true if you want to preserve your estate for your ultimate beneficiaries. Powers of attorney today have very powerful provisions that can be used to shelter your estate from the cost of your care as you're getting older. But of course, you have to carefully think about these powers. And we're going to talk in a few minutes about these so-called hot powers that you need to contemplate when you're putting together your powers of attorney. So what is a power of attorney? Power of attorney is an agreement where you are authorizing someone to act on your behalf. The person you name in the document is your agent. You are called the principal. You are required to sign powers of attorney at a time where you have the capacity to understand what you are signing. You have to know what the document is and that you're giving power to this person known as your agent to carry on with your affairs. There are usually two types of powers of attorney. One is the financial or so-called durable power of attorney that allows a person to manage your financial affairs. That includes managing any assets you may have, such as your cars, your house, stock, or life insurance policies. In the past, we used to see a lot of boilerplate powers of attorney that sort of listed the powers in general. They used to say, as found in our state law, and maybe have a general reference to the types of powers that were in our statute. And basically, it just said, hey, my agent has all these powers found in the law. With the changes brought about by a new law called Act 95 that was passed earlier this year, you now have to choose what powers you want and don't want to give your agent. The failure to choose means that your agent might not have certain powers to manage your affairs. And again, we're going to talk about those a little later. The other type of power of attorney is a healthcare power of attorney. This document is intended to allow somebody to communicate your medical decisions on your behalf when you are incapacitated. Decisions about where you're going to live, your medical care, accessing medical records, and even making end-of-life decisions are now addressed in the power of attorney for healthcare decision-making. So why do you need a power of attorney? I mean, is it really necessary, particularly if you're married? Can't your spouse just sign your name and act for you when you are unable to do so? Surprisingly, the law does restrict the financial decisions another person, even your spouse, could make for you. Here are some rather common examples. Selling your home. No one can sign your name on a deed transferring your interest in the house without a power of attorney or a court order. How about selling stock or cashing out investments? Can't be done without some legal authority. Selling your car. You want to transfer title of your vehicle to somebody else, there needs to be somebody named to have the power to transfer that ownership. Changing beneficiaries, whether it's on life insurance policies or retirement accounts, you need power of attorney. Giving your money or assets away to anyone else. And I'm not talking about having joint access to a bank account. I mean, that's an arrangement where you gave your spouse access to a jointly owned account. But if it was your bank account, could somebody just go to the bank and access it without a formal document? No. Could not access that account and transfer money. So those are some rather common transactions in our lives, and none of them can be done without some legal authority granting someone else access to these various assets. In our world of elder law, we're often trying to help our older clients qualify for Medicaid. Many times we need to remove names from a deed or liquidate a retirement account or maybe change beneficiaries on life insurance policies. Powers of attorney today are really scrutinized to make sure our agents have the power to engage in these transactions. If we don't have the authority in the document, often our clients are prevented from doing the planning to protect assets, such as the home, from the costs of nursing home care. So, and if we're talking about healthcare decisions, there are designated individuals who can make decisions about your care in our state law. Now, if you want to choose who can make these decisions for you, the power of attorney for healthcare decision making is that document. And if you want specific instructions in that document about your healthcare, you need to set forth that in advance, whether it's in the healthcare power of attorney or the advanced directive. Putting together your power of attorney takes some thought. The person named in your document has considerable authority to make decisions for you. Some people are not good at making financial decisions, so perhaps they should not be named in your document, while others, maybe they're really good at making medical decisions, and so those are the folks you want to consider for your healthcare power of attorney. Typically, my clients will name their spouse, if they're married, as their primary agent. Of course, that's not true in all cases. If we have somebody who's older and developing an illness, like a dementia, oftentimes they will not name each other. After your spouse, you do have some flexibility to name successor agents. In many cases, these can be your children. You can name one child to act for you with your financial power of attorney and another child to act for you with your health care power of attorney. And of course, if you want more than one child to act for you, you have some choices. You could name your children to act together. That's what we call a joint agency. Seems that my clients like their children act together when it comes to managing money or finances. Or you can name independent agents. Either person can act for you when making a decision about your finances or health care. Works well if kids live out of the area and you just need somebody to make a decision for you. The independent arrangement is very popular in the healthcare power of attorney. Of course, with these multiple agent arrangements, you have to think them through and decide whether these kids are going to get along. If they're going to butt heads about making decisions about your finances or healthcare matters, well, it's not a good idea to name two kids, whether you're naming them jointly or independently. So you might just need to name one individual to make the decisions for you. At the top of this slide is the term durable. My clients often ask me for a durable power of attorney. Thankfully, all powers of attorney here in Pennsylvania are presumed to be durable unless they state otherwise. The notion of what is a durable power of attorney means that the power of attorney will be valid even after you're incapacitated. Of course, that's the reason why most clients will want one of these documents today, but the whole notion of being durable was an old concept wherein powers of attorney used to cease to be effective unless they were noted that they were durable powers of attorney. So that's not the case anymore. Our state law now provides that all powers of attorney are durable. So don't worry about looking for that term anymore. Keep in mind that not all powers of attorney are the same. Each document has a series of powers that are given to your agent. They can vary in complexity. Most of those you'll find online are what we call the bill-paying powers of attorney. Basically, you can pay the person's bills or maybe sell their assets and use the proceeds to pay their bills. Other powers of attorney are a lot broader, and you can tailor the powers of attorney in terms of what powers you want to give to your agent. Perhaps you want to give a lot more power to your spouse and less to your kids. Some powers of attorney can only be used when you're incapacitated. They're called springing powers of attorney. And when we use these powers of attorney, usually we're talking about the financial power of attorney because you can set up your financial powers of attorney to be effective immediately. That is, they can be used right now. Some of my clients will sign a power of attorney if they're going away for a long time. They're going on a trip to Europe and they'll be out of the country for a few weeks. So they give somebody power of attorney to manage their bill paying for the time that they're away. But certain powers of attorney can't be used until you're incapacitated and a doctor certifies that you're not capable of making your decisions. So think through the details of your powers of attorney. You can make them as powerful as you want them to be with regards to the powers that you're giving a particular agent. And one last point, I did mention the state law has changed earlier this year with regard to powers of attorney. The law is generally referred to by lawyers as Act 95. It added some additional protections for those signing these powers of attorney. You may be aware that sometimes these documents are abused by agents. That is, the money that people are supposed to be managing is stolen or just mismanaged. So the state law now requires that certain powers be spelled out in your document for them to be used by your agent. These are the so-called hot powers, and they are related to estate planning. Here are a handful of them. You can get the idea of the type of powers you have to think about now. Changing beneficiaries, whether it's on life insurance policies, IRAs, and so forth. Giving money away, just taking money and giving it to somebody, whether it's to charities or children or otherwise. Adding rights of survivorship to bank accounts, just going on down and putting somebody's name on a bank account. Creating or amending a trust. Those are the type of powers that you have to actually spell out in your document now, and if you don't do so, your agent will not have the authority to use those powers. You can understand that those powers can dramatically alter who's going to inherit your money or property when you die. So the state wants you to carefully spell out those in the powers of attorney. Many of our clients, quite frankly, when I go over these, are fine with their spouse having these powers. The issue comes up with their kids, and sometimes they say, well, I'm okay with the powers going to my kids, but I want them to agree before they do any of these things, like give away money. I want them all to be on the same page. So, or maybe they restrict to whom they can give money to. They put some conditions in the document. So we talk through these, and usually we come up with some agreement as to how they're going to be granted, if at all. So keep in mind, not all powers of attorney are created equal. All right, many of the older powers of attorney that we used to see 10 to 15 years ago had both the financial and the healthcare powers blended together. You might have perhaps one paragraph in an old power of attorney that mentions the healthcare powers. Well, over the years, it became apparent that we needed a separate power of attorney for healthcare. It was easier for our clients just to take that document to the hospital in the event of an emergency. You didn't need all of the other powers for financial matters in the healthcare document. So the healthcare power of attorney is now a separate document, and it can only be used when you're incapacitated. If you don't have the ability to make medical decisions for yourself, the doctor is going to have to turn to somebody else. And that's when they turn to the agent to say, hey, we need a medical decision about this individual made. You have the authority to do so, and please instruct us as to how to proceed. Healthcare powers of attorney can authorize your agent to make any decision about your day-to-day care, such as where you're going to reside, medical treatment, the hiring of doctors, prescribing any medication, are you going to receive caregivers, on and on. Just about any decision you can make for yourself with regard to your personal care, the person in your healthcare power of attorney can make that decision for you. In particular, they can get your medical records. There are rules about who can access your records under the HIPAA laws, and these are, of course, federal protections for all of us as to who can access those records. And if you name somebody in your healthcare power of attorney, they have the power to access those records. Just an FYI, before we move on to advanced directives, I want to just make 2 points about powers of attorney. Powers of attorney can get stale, kind of like stale bread. They get old and outdated. Financial institutions in particular are not really comfortable with accepting a power of attorney that's really old. So if you drafted a power of attorney, let's say when your kids were really young and you were just starting out with a family, and you just put a document together in the event something happened, and now it's you're 20, 25 years later, your kids are grown up and they're out of the house, it might be a good idea to get that document updated. Not just because who you put in the document is probably not appropriate at this time, but the laws are always changing in the area of powers of attorney. The way powers of attorney looked 20 years ago is totally different from the way they look today. And consequently, that throws banks and other financial institutions off. If you showed up with a power of attorney for your parent from 1989, and they're going to go, is this still valid? It doesn't look like the documents we honor today. And they might ask for a letter from the lawyer to make sure it's still a valid document. So you can have all sorts of problems with what we call the stale or really old powers of attorney. And there are specific powers of attorney for somebody with a mental illness. So if you have somebody with a schizophrenia or a disorder like a manic depressive type disorder that comes and it goes, these powers of attorney for mental health illnesses will have very specific instructions about how somebody with a mental illness wants to be treated. They could set forth what institution they want to go to, what doctor they want, what type of care or medication they wish to receive. So there is a variation on the healthcare power of attorney for people with mental illnesses. Okay. Which brings us now to advanced directives. An advanced directive is a document that gives instructions about how you want to be treated if you are incapacitated and you are suffering from what they now call an end-stage medical condition. Think terminal illness. That's what we used to call it, but now the law does refer to it as an end-stage medical condition. Or you're permanently unconscious, such as in a coma or a vegetative state. So it implies it in a very narrow context. You have to be at the end of your life, and a physician has to certify that you're incapacitated, as well as there's no realistic hope of recovery. And I say a physician, you could have 2 physicians, or you could decide how you want the document to be structured, but certainly someone has to certify that there's no realistic hope of your recovery. These documents used to be known as living wills, and in some cases you'll still see the forms with living will at the top. The term turned out to be really confusing for most clients, so a lot of folks now are using advanced directive or quite simply end-of-life instructions. Today, you'll see these documents combined with the healthcare power of attorney, and they set forth the general philosophy about your care. The documents today will typically say you do not want the initiation or continuation of medical care that's simply going to prolong your process of dying. And there's often a list of the common type of medical care you'd rather decline or discontinue. Ventilation, feeding tubes, cardiac resuscitation, blood transfusions, and so on. It will go on to say that you want to be kept comfortable and free from pain. You don't want heroic measures to prolong your life, or rather the process of dying. The advance directive needs to be delivered to the attending physician, so it's usually collected upon admission to the medical facility, and then it's scanned into the records so the treating staff knows your wishes. You can revoke this document at any time, and in fact, you can revoke powers of attorney at any time. And if you're competent, you can override what's in your advance directive. You may have decided, I don't want the following type of care in the event I'm terminally ill, but when the time comes and you're competent, you may change your mind. So just because you've set forth this in advance directive doesn't necessarily mean it has to be followed. It's typically only followed when you're incapacitated. You cannot express your wishes. Now, we used to see a lot of check the box forms for these living wills, rather. I used to say, I do or do not want the following type of care. You had to go down a list and pick them. But those were problematic, and here's an example. If you said, I don't want antibiotics, and yet antibiotics could relieve pain, it created some confusion with the medical staff as to whether they should or should not administer the antibiotics. So now we tend to have a general philosophy. And here are the examples of the type of care that you would rather not have administered. They're going to just prolong the process of dying. But you're really giving your healthcare agent some discretion to decide when and under what condition those should be declined. So the form today is a more flexible form that works better for most of our clients. Well, what if you haven't drafted a power of attorney? Comes up periodically. Somebody just didn't want to draft such a document. They're concerned about the abuse of the document. It used to be you had to go to court. We will mention guardianships in a moment, but nowadays we have a statute that was passed in 2006 allowing for what's called a personal representative for healthcare decision making. This is a statute that sets forth basically a pecking order as to who will be handling your healthcare affairs if you're incapacitated and you don't have a power of attorney. The statute tends to track the typical order of authority in a family. It starts off with saying your spouse is in charge. Then it goes down to your kids collectively, all of them, equally. Then it goes up to parents, then back down to siblings, and eventually it goes to grandchildren and eventually other interested parties. So it could be a real mess if any part of those the family unit, if you will, doesn't get along. Here's a classic problem. It names the spouse as your healthcare representative, but it also says if there are children from a first marriage, they're on the same decision level as the spouse in the second marriage. And sometimes those groups don't get along, so there could be a real dysfunctional group of people trying to make a decision about your healthcare. Now, of course, statute's better than not having a safety net, if you will, at all. But in the years since this has been passed, it hasn't always been the most effective. Sometimes you have dysfunction in the family and it's not working the way it should, or the medical institutions just aren't aware of it. I've frequently had to write letters to nursing homes and other facilities saying, hey, please follow the statute and allow the following individual to make a decision for my client. But it is a safety net if you don't have a power of attorney. DNR orders are separate from powers of attorney or advance directives. They apply only to cardiac arrest. If you're having some heart issues, you can ask the doctor for a DNR order. And of course, do not resuscitate order. It's signed by the doctor, and it directs emergency personnel not to resuscitate you in the event of a cardiac arrest. If it's an out-of-hospital DNR order, it usually takes the form of a bracelet or a necklace, some sort of document that can easily be located in the event you're suffering from heart failure. So, well, last topic is the guardianships. It's the option of last resort. If you have no power of attorney and you need somebody typically to manage your financial affairs, then a guardianship might be needed. Here, a petition is filed at the local court, and a judge is being asked to appoint a guardian for you or your loved one. Sometimes this is an Alzheimer's patient who's never signed a power of attorney, and we need somebody to manage their home or their money. In other cases, I'm asked to file a petition for a young disabled adult, someone with a Down syndrome or mental retardation, and somebody needs to be appointed to sign agreements for care for this individual. So the judge will have a hearing, usually very informal. It's often, I find, in the judge's chambers rather than in an open court. And the judge listens to testimony from the person who wants to be the guardian and also from the doctor who has to certify that this individual is in fact incapacitated. Many decisions, of course, once the order is issued, are controlled by the court. You don't have as much power as you would have in the power of attorney. So you typically cannot make, for example, end-of-life decisions without court approval. Can't sell a person's house without court approval. You can't give away a person's money without court approval. So there's lots of things that you have to go to the judge for if you want to take steps to deal with the finances or make extraordinary decisions for this person. And since it's a court proceeding, it could be contested. Lots of people have to be given notice about it, and a lot of times you'll have families come in and they'll fight about who's going to be the guardian for the parent. Guardianships take time, and they cost a lot more money than powers of attorney. So yet again, another reason you may want to plan ahead and sign a power of attorney when you're competent so your family doesn't have to rush into court. Guardianships also come up with regard to minors. If you and your spouse are deceased, a guardian is usually named in your will to take custody of your minor children. Could be siblings, parents, trusted friends, whoever you feel would be a good guardian for your children. Someone needs to take physical custody of them and then make day-to-day decisions, such as where they're going to live. Guardians of the minors can be named in any estate planning document, but normally you will see it in your will. And if you and your spouse are incapacitated, such as both of you are in a car accident together, you will want somebody to take temporary custody of your minor children until you recover. That document is called a standby guardianship form. It's a separate document from your will or power of attorney, and in it you appoint somebody, a person or maybe persons, to be there for your minor children when you're not able to do so. Usually there's a time limit on how long they're going to be appointed as the guardians for your kids before they have to then go to court and get the formal approval. But it's an important document from my younger clients with minor children. They usually come in, they want some basic documents put together, and that's one of them that I usually recommend if I see minor children in the family. I should point out, when we're talking about these documents, all kinds out there being promoted, and you can go to any number of websites perhaps and download a form, power of attorney. And with my younger clients, sometimes that makes sense if they don't want to spend a lot of money. But for my clients as they're getting older, the sort of form documents don't serve them well as they develop an estate. They have assets and investments and property and so on. So I recommend that they go see an attorney as they develop an estate and spend a few dollars on good powers of attorney. And in the end, we're not talking about a lot of money here. We're talking usually a few $100s for powers of attorney. So don't be overwhelmed by the cost. These documents are fairly common. You can get them from good attorneys who practice in elder law and estate planning. So I've given you an overview of the basic incapacity planning tools, some powers of attorney, advanced directives, person representative statute, as well as guardianships. There may be some more topics that interest you, and I encourage you to visit our website at paelderlaw.com. There's a lot of information on there, great blog articles about these topics and others. You can sign up for an email newsletter if you'd like, and certainly contact us if you need an appointment or forward our information to somebody who might need help. Once again, my name is Attorney Matthew Parker. I want to thank you for listening to today's webinar. Our next topic is in December. and it's on veterans benefits, benefits that will pay for long-term care. So if you're interested in that, do sign up for it. Hope to see you then. Thank you very much.